Tonight, the Supreme Court has struck down a controversial ban on large-capacity magazines, sending shockwaves across America. The decision fundamentally alters the landscape of gun control in the United States. For gun owners, it's a vindication of Second Amendment rights. For others, it's a setback in the fight against gun violence. The reaction was immediate and deeply divided. The Supreme Court has offered its answer, but the debate is far from over. To understand today's ruling, we need to look back at the history of these laws. The debate over magazine capacity entered the national stage in 1994 with the federal assault weapons ban, which limited magazines to 10 rounds. The law aimed to curb violent crime, but it expired in 2004 when Congress declined to renew it. Afterward, states like California and New York enacted their own bans, often stricter than the federal law. These state bans faced immediate legal challenges from gun rights groups who argued magazines are essential firearm components in common use. Federal courts were divided. Some upheld the bans for public safety, others struck them down as infringements on self-defense rights. This patchwork created confusion. What was legal in one state could be a felony in another. For example, a magazine legal in Arizona could be illegal in California. This inconsistency, known as a circuit split, is often why the Supreme Court steps in. The nation needed a single definitive answer. The legal tug-of-war over magazine bans set the stage for today's Supreme Court decision. The question, are these bans constitutional or do they violate the Second Amendment? Today, the court has spoken. The answer will reshape gun laws nationwide. Today's ruling follows a years-long legal battle that began in Washington state. In 2022, Washington banned magazines over 10 rounds to prevent mass shootings. Gun rights groups sued, arguing the ban violated the Second Amendment. After a federal court upheld the law, the case reached the Supreme Court. Now the nation watches as this case shapes the future of gun laws. This morning, the Supreme Court released its opinion in Chaquan versus Washington, striking down the state's magazine ban in a 6-3 vote. The majority opinion, authored by Justice Neil Gorsuch, solidifies the legal framework established in the Bruen case. The court's core argument: bans on common firearm magazines have no historical precedent in American law. Justice Gorsuch wrote, "Americans have always had access to arms in common use for lawful purposes." The opinion emphasizes that the Second Amendment protects weapons in common use today, not just those from the 18th century. The court rejected public safety arguments, stating the Constitution does not permit stripping rights in the name of potential future crimes. The Second Amendment right is not a second-class right, the majority declared. Magazines holding more than 10 rounds are considered arms under the Second Amendment and cannot be banned if they are in common use. The decision sets a powerful precedent, making it extremely difficult for states to restrict magazine capacity. The legal battle is over, but the political and social fallout is just beginning. The ruling will impact tens of millions of Americans and reshape gun laws nationwide. The Supreme Court has spoken. The nation must now respond. Justice Gorsuch's opinion applies the text, history, and tradition test from Bruen. The court's focus: is there a historical precedent for banning common firearm accessories? The answer: no. The opinion dismantles the state's historical arguments, finding no tradition of banning standard magazines. The court examined colonial militias, frontier life, and post-Civil War laws. None banned common firearm components. Limiting magazine capacity, the court argues, is a modern invention with no roots in American history. The majority rejected claims that high-capacity magazines are unusually dangerous or military only. Many technologies, the court notes, began as military innovations before becoming common civilian tools. The sheer number of these magazines owned today proves they are in common use and thus protected. The court warns that allowing bans on magazines could lead to bans on any firearm feature, eroding constitutional rights. Any ban on a class of arms commonly owned for lawful purposes is unconstitutional, the court declares. This leaves little room for states to regulate widely available firearm features. The ruling redefines the limits of gun regulation in America. The dissenting justices, led by Justice Sonia Sotomayor, offered a starkly different view. Their opinion is a passionate plea to consider the real-world consequences of the court's decision. The dissent argues that the majority's rigid focus on history ignores the dangers of modern weaponry. Justice Sotomayor wrote, "The framers did not intend to create a suicide pact." She cited recent mass shootings where high-capacity magazines enabled devastating casualties. The dissent points to historical laws regulating dangerous and unusual weapons, arguing that large magazines fit this category. A magazine that holds 30, 50, or 100 rounds is not a tool for self-defense, it is a tool for mass murder, the dissent states. The majority, they argue, treats these devices as if they were no different from colonial muskets. The dissent accuses the majority of judicial activism, overriding the will of elected legislatures. Justice Sotomayor warns. Today's decision will have deadly consequences. By stripping states of tools to combat gun violence, the court has made the country more dangerous. The dissent frames the ruling as a tragic failure to protect life. The debate over gun regulation is far from settled. The consequences of this decision will be felt for years to come. The Supreme Court's decision is a political earthquake, with aftershocks across the nation. Magazine bans in states like California and New York are now unenforceable, likely leading to a surge in sales. Gun shops will quickly restock, and the firearms industry is poised for a significant boost. Politically, the ruling energizes both sides ahead of the 2026 midterms. Conservatives hail it as a victory for Second Amendment rights. Progressives call it radical and dangerous. The decision will dominate campaign ads, debates, and fundraising. In communities where bans were popular, fear and anxiety about gun violence may rise. Local leaders may seek new creative regulations like zoning laws or ammunition taxes. In gun-friendly areas, the ruling is seen as a restoration of rights and normalcy. The economic impact is substantial, with millions in new revenue for manufacturers and retailers. Supporters call it a win for American jobs. Opponents call it blood money. The economic, moral, and political debates are now deeply intertwined. The ruling's impact will ripple through law, politics, and society for years. America enters a new era of gun rights and regulation. With magazine bans off the table, what comes next? We asked legal experts and policy analysts. The consensus: the legal fight over gun control is far from over. It's shifting to new battlegrounds. Gun control advocates will pivot to time, place, and manner restrictions, like expanding gun-free zones and strengthening red flag laws. Legislatures may hire historians to craft laws that can survive judicial scrutiny under the new standard. The focus will move from banning hardware to regulating how, where, and when guns are carried. Gun rights advocates see this as a chance to challenge other laws, including assault weapons bans and waiting periods. Any law without a clear historical analog is now vulnerable to legal challenge. Experts predict a flood of lawsuits aimed at dismantling modern gun control in states like California and New York. The next major battle bans on certain semi-automatic rifles, which gun rights groups argue are also in common use. The Supreme Court may soon decide whether these bans are constitutional. The Chaquan decision has not ended the debate. It has raised the stakes. The terms of engagement for future battles are now set. The fight over America's gun laws is entering a new phase. Tonight, we stand at a pivotal moment in American history. The Supreme Court's decision to strike down magazine bans has redrawn the boundaries of the Second Amendment. The consequences will unfold for years, affecting laws, politics, and society. The debate is far from over. State legislatures and courts will grapple with the ruling's impact. Upcoming elections will become referendums on this decision and the future of the court. The conversation will play out in town halls, on social media, and at dinner tables nationwide. In times like these, knowledge is your most powerful tool. Move beyond rhetoric. Read the court's opinion, the dissent, and listen to experts from all sides. Understand the history and arguments shaping the debate. Pay attention to your elected officials' responses. Your voice matters, whether you're a gun owner, advocate, or concerned citizen. This is a time for engagement, not apathy. Register to vote. Contact your representatives and participate in civil discussions. The Supreme Court has spoken, but the final word belongs to the American people. Stay informed, stay engaged, and make your voice heard. Good night.